Hi, thanks for using My Court Coach. I'm Sarah, and I'll be your instructor today as we talk about the response to petition form, also known as form FL120. As with all our court forms, you want to fill in your identifying case caption information at the top. If you are filling out this form, chances are you've been served with a petition and summons that is requesting either a divorce, a legal separation, or an annulment. So you would mark the box identifying what it is you're responding to, and then specify whether this is for a marriage or domestic partnership. If you want to join in on that request, mark the box that says "and request for." Below that, you need to identify what is your legal relationship. Either you are married, in which case you mark box 1A, or you are domestic partners, in which case you'd mark box 1B or C, depending on whether or not your domestic partnership was or was not established in California. There are some residency requirements if this is a divorce. One of you has to have lived in the state of California for at least 6 months prior to, and in the county in which you are filing at least 3 months prior to filing for divorce. So you'd want to identify which of you qualifies for that residency requirement. If it's both of you, you can mark both boxes. If this is a domestic partnership that was established in California, you would mark box 2B. Neither of you currently has to be a resident or have a domicile in California to dissolve your partnership here. If this is a same-sex marriage and if you were married in California, but you currently live in a state that does not recognize and will not dissolve your marriage, you are welcome to file here, provided that you are filing this petition in the county that you were married in. And then you would mark box 2C and list the state that you are currently living in, or the county and state that you're currently living in. In line 3, you need to list if this is divorce or legal separation, your date of marriage, date of separation. Date of separation is going to be the date that an overt act took place in furtherance of separation that you think you could defend on the stand if need be. Tally up the number of years and months total that you were married and include that in line 3A3. 3B, if this is a domestic partnership, same thing, only the start date is not date of marriage. It is the date that the domestic partnership was registered with the California Secretary of State or other state equivalent. And again, you want to tally up the years and months for that domestic partnership. Line 4, you need to list if you have minor children as a result of this relationship. If you do not, you would mark box 4A. If you do have minor children, you would mark box 4B and list the children's name, birth dates, and age. If this is not enough space for you to include all that information, you're welcome to include an attachment. And if there is a child who is not yet born of this relationship, but the mother is pregnant with a child, then you would mark box 4B2. If there is or are children of this relationship that were born prior to the domestic partnership or the marriage, and there was a voluntary declaration of parentage or paternity signed at birth, you would mark box 4E and attach a copy of that to this form. Page 2, we go over the legal grounds for the termination of this relationship or the separation. So you're going to have to look at the petition in order to fill this part out. If you contend that the two of you were never legally married or had never registered a domestic partnership, you would mark box 5A. If you agree that you were legally married or you have registered a domestic partnership, but you do not agree with the grounds set forth by the petitioner in item 5 of their petition, mark box 5B. If you are joining in on the request to either divorce or legally separate or annul this marriage or domestic partnership, you would mark box 5C. If this is a divorce or legal separation, identify which one in line 5C1, and then the grounds are either going to be irreconcilable differences or permanent legal incapacity to make decisions. Most cases are filed alleging irreconcilable differences. It's a no-fault divorce state, and that's just the easiest thing to mark. If you choose to mark legal incapacity, just be aware that you're going to have to prove that legal incapacity down the road. If this is based off of an annulment request and that is specific to incest or bigamy, you would mark the appropriate box in line 5C2, whether it's A or B. If it is a voidable marriage based on either the respondent's age at time of marriage, prior existing marriage, or unsound mind, fraud, force, physical incapacity, if those are any of the grounds you want to allege as part of a nullity, then you would mark box 5C3 and the grounds that you believe exist. Again, if there are minor children, we need to fill in 6, which has to do with custody visitation. Keep in mind that your response, much like a petition, is an outline to the court of the relief you'll be seeking through this case. You cannot seek something that is not specifically identified here. So if you want sole custody, don't mark joint custody, because the court will not consider sole custody where joint custody is marked. So as far as legal custody goes, that's going to be pertaining to the health, safety, education, and welfare of the children. If you want sole decision-making power over that, mark respondent. If you want the other party to have that decision-making ability, mark petitioner. And if you want to share in that, which is probably the most common, you would mark joint. As far as physical custody goes, that is the party who has the children in their care most of the time. And again, that can be petitioner, respondent, or joint. If you are saying that you want sole physical custody, for instance, then the other party, you should be granting or requesting that they be granted visitation rights at the very least. So you would only fill out visitation if you were asking for one party to be awarded custody of the child or children. These forms here are additional custody provisions. You can certainly attach them and include requests for very specific orders pertaining to custody to be made. I personally don't do that. I like to keep the petition or the response to the petition as broad as possible in terms of the relief I may be asking the court for. If there are children at issue, the court does have the ability to make child support orders, and that does not need to be specifically requested, and that's just for public policy reasons. But if there's anything you are requesting as far as child support goes beyond the statewide guideline formula that's set forth by legislature, then you can identify that in 7D. In Field 8, we address the issue of spousal support. If this is a divorce or legal separation or a domestic partnership, then you can request for spousal support to be awarded to either party and identify the party you want it to be awarded to. You can ask the court to terminate the court's ability to award spousal support to either party. And again, you can ask or identify which party you want to be prohibited from asking for spousal support, again, as a result of this marriage. If you want the court to hold on to the right to make spousal support determinations in the future, but maybe you don't necessarily need it today, you can ask them to reserve their authority to make that order in the future and which party you want to be able to have the right to request it in the future. If there are any other orders pertaining to spousal support you want to make, you can identify that specifically in 8D. Again, if this is a divorce, legal separation, or domestic partnership, then the court has the right to confirm separate property assets to one of the parties or another. If there are no such assets or debts, you would mark box 9B. If there are a couple different ways of identifying those. You can identify and specify each asset or debt that you think belongs to the separate property of one or the other party here. You can use the property declaration form, that's FL160, to specifically identify those assets and attach that to this. Or what I generally do, because again, I like to keep things as broad as possible in terms of the relief I can request, I just generally put in the general definition of separate property. Again, that's all property acquired by a respondent prior to marriage, after separation, or by inheritance, devise, or descent, confirmed to respondent. Community property. Chances are, if this is a short-term marriage, you may not have any assets or debts that qualify as community property. However, if this is anything longer than a short-term marriage, there probably are assets that were acquired during the marriage and hence belong to both parties. And you want to make sure that you are selecting that the court has the right to determine the division of those assets. And again, just like with page 2 and the separate property, you can specifically list each asset or debt. You can refer to the property declaration and it can be listed there. Or again, what I do in these situations, I just put the generic definition for what community property is, and that is the broadest way of preserving my right to claim an asset or debt as later community property. There are some other miscellaneous requests. Under 11, you can request that either party have their attorney fees paid by one of the parties. 11B, if you are requesting your name to be restored back to your maiden name, you can mark 11B and then specifically list what you want your name to now be and include first name, middle name, last name. And finally, with all petitions and responses, under 11C, I write written statement of decision on all contested issues. Hopefully you resolve your case amicably by settlement, but if not and it goes to trial, then you want a written statement in case you need to appeal down the road. So finally, you will fill in your name here, sign, date, and that completes the response to petition form FL120. I hope you found this helpful. Good luck.